Significant Data Fiduciaries, an extension to data fiduciaries for some reasons. Special roles and rules for them under the draft DPDP rules 2025. Let's talk about that in this video. Welcome to my YouTube channel where you daily see new content on data privacy, and as I said, we are going to talk about the rules for significant data fiduciaries. What's a data fiduciary first? A data fiduciary is any organization that processes personal data. Personal data means personally identifiable information, and processing by Indian DPDP Act means you are collecting, you are storing, you are using, you are sharing with third parties, or you are deleting personal information of any citizen of India in your organization. Then it means you need to be compliant with the Indian DPDP Act. And if that data is sensitive, or if you are doing it at a very high volume, millions and millions of records, then you become a significant data fiduciary, right? And for significant data fiduciary, there are certain extra norms because all countries believe that the sensitive information has to be handled with much more care. We spoke about sensitive personal information multiple times earlier. It's that piece of information which, if it is misused and lost, then it can harm the individual. For example, my healthcare records. It could be misinterpretation, misrepresentation, unsolicited marketing that comes to me for alternate therapies and medicines and pharmacies. It could be financial transactions. Loss of financial information could be dangerous. My public reputation, if I lose my personal returns, etc. My credit ratings, and if I lose credit card information access, then I could even have a financial loss, right? And then social media platforms, they process a large amount of personal data, billions and billions, and in fact they are available worldwide, so they have to meet norms of all the countries around the world, and high security areas which also use biometrics. So these are a few examples of significant data fiduciaries. What does the Indian DPDP Act and rules expect from significant data fiduciaries? You are expected to appoint an India-based data protection officer. I'll tag my playlist on data protection officers, but that is what you are expected to do if you are an Indian company handling large volumes of sensitive information. You should perform regular internal audits for all your processes to be sure that there is less chance of breach, and you take care of the rights of the data principals, and you should perform data protection impact assessment, process by which you are checking that the chances of breach are minimized, and if there is still any possibility, then how would you mitigate the risk, right? So risks are documented, mitigation plans are prepared. I'll tag my playlist on DPIA also in this video in the description, and all these are to be provided, the information related to them, any significant observations that you get across when you perform internal audits and DPIA, you should report them to the Data Protection Board of India at least once in a year. Every 12 months, this has to be provided to the Data Protection Board of India. The software that you are going to use to handle your privacy items, privacy information as well, you need to provide due diligence report of that software. You also need to do due diligence on other softwares that are handling personal data, so that there is no possibility of impact to the rights of the data principal. Unauthorized access, right to erasure, right to withdraw. We did a video a couple of days back on the rights of, in fact yesterday, on the rights of the data principals in India. So your softwares that you are using should not violate any of these rights. Frequency of the above information, as I mentioned earlier, the significant observations, this should be shared with the Data Protection Board of India every 12 months, which means the frequency for conducting DPIA by Indian law would be 12 months even for significant data fiduciaries. In some geographies, this period is reduced, and it is generally recommended that if you are a real high volume, sensitive, significant data fiduciary, then DPIA should be performed in the frequency of 3 to 6 months. Privacy impact assessments may go beyond, which is like a year or so, but then at least once in a year you have to report it to the Data Protection Board of India as well. So, and the personal data that you have collected and the traffic flow that has come with that personal data should not flow outside the geographies of India. In the next video, we are going to talk about the cross-border data transfer as well with respect to the DPDP rules. So that's about significant data fiduciaries and their role under the DPDP rules. I hope you like the content of the video. Please press the bell and the like icon. Subscribe to my channel if you have not already done that, and share your feedback in the comment section. Thank you.